Okay, so you've signed your Revocable Living Trust. Your documents have all been executed. They're all in effect. That's great, but is it actually working? One of the key differences between a will and a trust is that with a trust, you actually have to fund it, meaning that your assets actually have to be transferred into the trust for the trust to control it. I'm Darcel Lobo. I own Dow Law Firm. I've been an estate planning attorney for 16 years. And let's talk today about how to fund your trust and make sure it actually works correctly. Now, let's start with what does it mean when I say to fund your trust? That can sound a little vague or a little confusing. Funding your trust just means transferring your assets into the trust. So, any real estate that you own, financial accounts or investments, personal property, vehicles, things like that. We need to get those actually into your trust so your trust controls them so that upon your passing, they're distributed according to what the terms of your trust say. Now, there are some things that you may not actually title into the name of your trust directly, especially with some kind of like retirement account. So, IRAs, 401ks, those type of accounts, you may not actually title into the name of your trust, but instead you may be looking at naming your trust as the beneficiary of those accounts, maybe after a surviving spouse. So this is where you're going to be talking to your financial planner and your attorney about what is best for you. But generally speaking, otherwise you're looking at transferring your assets into the trust. And this is key. This really matters because if you have gone through all the steps to create a revocable living trust, so let's say you've hired an attorney, you've had the estate plan prepared, you have your revocable living trust, you have your pour over wills, you have your power of attorneys, you have your directives, you have all the things that you need for a comprehensive estate plan. But if you don't have your assets in that trust, the trust is not going to be able to control it. The trust will not be able to do its job if it does not own the assets. And so at our office, when we prepare your estate plan, we make sure that when we sign your trust documents, we are also signing deeds to transfer any Washington property, any real estate into your trust. So we do that for you at our office. So we prepare those deeds, we sign them, and we sign the trust, and we send them off to the county for you for recording. We do all that for you. You don't have to worry about it. When it comes to personal property, your household goods and belongings, maybe jewelry, vehicles, boats, trailers, RVs, things like that, we don't actually go through and retitle all those items individually. I mean, a number of those items don't actually have titles, right? So, like your personal household belongings, you don't have titles for those. But for vehicles and boats and RVs, you do. However, we don't need to go through and retitle each of those, especially as you buy and sell vehicles throughout your life. What we prepare with our trust for you is a personal property assignment that says whatever personal property that I own, including vehicles, including RVs, including boats, including your household belongings, including jewelry, all those items are considered personal property, and we do an assignment that says all of that personal property goes into my trust. So it's a real easy way to get all of your personal property into your trust without you having to go to the Department of Licensing to update all those titles on your current vehicles. And then as you buy and sell them in the future, the personal property assignment catches it all and puts it into your trust for you. When it comes to financial accounts like checking and savings and CDs, things like that, it can be a little bit too much to have to retitle the name of all those accounts into your trust. And so what we actually do instead with those accounts is to name your trust as the beneficiary. That way, upon your passing, those accounts flow into your trust and then get distributed according to what the terms of your trust says. So that's usually easier for our clients to do it that way so the accounts all stay the same. There's no change in titles or account numbers and debit cards, things like that, or checks. That all stays the same. And instead, you just have the trust name as a beneficiary for that account to, upon your passing, go through the trust and be distributed to your heirs as you've outlined in your trust. So, some common pitfalls that we see with trust is that we will get everything funded into the trust when we create the trust for you, and you've named the trust as beneficiary for financial accounts, so all is good. But then 5 years down the road, 10 years down the road, maybe you've bought more real estate, maybe you acquired more assets, and you have not gotten them titled into the name of your trust. That's one thing that a trust requires, is that for the long term, once you create the trust, you have to make sure that your assets are in the trust. So if you buy another home, great, you need to give us a call and let us know. If you've acquired new financial accounts or investments, great. Make sure your trust is named as beneficiary to those accounts. We want the trust to control all those assets, because what happens if it doesn't? With all of our trust plans, we include what's called a pour over will. The pour over will is a backup plan. It's a plan B. We do that because sometimes clients will create the trust and forget to put future assets into the trust. So the pour over will catches those assets and puts it into your trust for you, but it only does so through probate. So let's say we've done your trust for you, everything's in your trust, and then 2 years down the road, you buy another home, but you don't put it into your trust and you pass away. So what's going to happen? The trust is still going to control distribution, but we have to do some extra work to get that property into your trust. Now, during your lifetime, we could have just deeded it into your trust. Now that you've passed, what we have to do is use a pour over will that says any probate assets are to go to my trust. We have to open probate to get that one property into your trust. But the whole point of the trust was to avoid probate, at least for most of our clients. That's the primary reason. And so we want to make sure that you don't need the pour over will and that any future assets are getting transferred into your trust. It does happen. Sometimes clients forget, so we include the pour over will as a backup plan. But again, we never actually intend to have to use it. So when you're creating your estate plan, and what we provide our clients, when we prepare the trust, there's an exhibit attached to it that says these are the assets that we put into the trust. In the back of your trust binder are forms that you can fill out that list your various bank accounts, investments, things like that. You need to fill that out. That way your children or other heirs know where are all the assets. There's no central database to be able to pull an asset list. You can order a credit report to get a list of debts. There's no such thing for an asset list. So when someone passes away and we don't know what assets there were, we're having to go through mail or tax returns and just trying to piece it all together. If you keep a comprehensive list of what the assets are and what's in the trust, it's going to be very helpful to your family and heirs to know what the trust controls and to be able to get it to the right person as you've outlined in your trust. If you have, real estate, make sure you're working with an attorney to get it into your trust. If you have a financial advisor or a financial planner, you're working with him or her to get those assets either titled into your trust or the trust named as beneficiary for those accounts. Also, with the trust package, we include what's called a certificate of trust or certification of trust. This is like a 4-page document that outlines the name of the trust, when it was created, who's authorized. You're going to need that to give that to your financial planner or your banker when you want to name the trust as beneficiary or retitle the account in the name of the trust, because that way it shows them kind of who's authorized and what the name is without giving them the full details of your trust. The full details of the trust is really none of their business. And so we use that 4-page document to give them a short summary of who's authorized, how to title it, the date it was formed, without giving them all the details of your trust. So if you need help with creating your Revocable Living Trust or amending your Revocable Living Trust, feel free to reach out. Our number is 206-408-8158, and we'd be happy to help you. Thank you.